Hi, and welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo. On this podcast, as always, we talk all things estate planning and elder law and anything else that we choose to talk about. Now, today we do have a legal technical topic that we want to discuss with you, and we are going to spend some time discussing fiduciaries today. So, a fiduciary is a person to whom property or power is entrusted for the benefit of another. So that's just a fancy way of saying the person that you name as your financial power of attorney, the person you name as your healthcare power of attorney or healthcare proxy, the person you name as an executor in your will, and finally the person that you name as the trustee in a trust. So there's basically four main fiduciaries that we want to talk about today. Now, as always, I want to remind you that you should not take legal advice from this show or any other show for that matter. If you need legal advice, please contact an attorney in your state who is licensed to be able to handle the matter that you are looking for specifically. So, for example, if you're looking to discuss fiduciaries or any other topic regarding estate planning and elder law, I highly recommend that you seek out a certified elder law attorney in your area, licensed in the state that you live in, to be able to assist you. And they will definitely be able to give you their opinions and help you through the process. This podcast is for informational and educational purposes only. And if you would like an attorney-client relationship, please call us at 717-845-5390. That's 717-845-5390. Or check us out on the web at www.bellomoassociates.com. Awesome. All right, so this topic is actually pretty hot right now. In fact, as many of you know, at Bellomo and Associates, we do workshops. We do all kinds of workshops. We have pre-planning workshops. We have crisis planning workshops. We have special needs workshops. We have probate administration and trust administration workshops. And soon we will be rolling out our fiduciary workshops. So, as we were preparing the materials for the new fiduciary workshop, it dawned on me, gee, why don't I do a podcast on this exact topic? Because we have been getting a ton of calls, right? So, I look at fiduciaries kind of as a superhero, you know. They're the ones who are going to come in the biggest time of need and help you, right? So, oftentimes, I think, you know, as children in particular, we really want to be named. It's an honor. We're hurt if we're not named. As a child, I'm talking about here, right? You want to be the one picked. The truth is, I don't think most children have any idea what they're signing up for. I think they want the title. I think they want the honor, but it is a lot of work. And it's a lot of responsibility. So I did want to take some time today on this podcast and kind of talk a little bit about the four fiduciary roles primarily, and also kind of what does it mean? What does it entail? I think as people are preparing their estate plans, they are very quick to name someone. It's obvious to them. It's okay. Well, it has to be this person, or it has to be that person. Usually, it has to be my oldest child, or it has to be this child or that child. And the truth is, I'm not certain that that's actually a true statement. Nor am I certain that that's actually a great idea. So I'll talk a little further about that today. But it is an awesome responsibility, and by awesome I mean huge. Big, a massive undertaking. I don't necessarily mean awesome as in like fun or great or anything in that kind of context. More of it's a lot of work. It might be an honor, but it's certainly a lot of work. So let's take the first one. So the first one is going to be the financial power of attorney. When you lose capacity, who is that person that's going to step in your shoes? Who is going to make sure that your decisions are carried out, that your bills are getting paid, that your mortgage is getting paid? Who's going to be taking care of the finances? That is the financial power of attorney. Now, with a financial power of attorney, You certainly want to make sure that someone is impartial, right? That's a big thing. Probably someone who's fairly local, although with technology that may not be quite as big of a deal anymore, but it certainly doesn't hurt, particularly if a loved one is in a long-term care facility or it has in-home care coming in. Somebody wants to be present. Somebody wants to be the biggest advocate for them. And that could be the financial or the healthcare agent, but that's why I'm saying, maybe nearby isn't a bad thing. Somebody definitely who is trustworthy, somebody who's assertive, somebody who is organized and pays a lot of attention to detail, and finally, somebody who is diligent. Now, that doesn't necessarily qualify all children, now does it? A lot of those attributes are not attributes that a lot of children possess, or certainly not all children, that's for sure. So you just want to make sure that you're picking someone who can carry out your wishes, make sure that your bills are paid, make sure that important decisions in regards to finances are made. Not only that's right for you and your family, but also that they do it correctly and that they follow through on what it is that you would want them to do. So on the healthcare side, a lot of the same attributes. You want them to be impartial. You want them to be nearby. Again, from a standpoint of if a medical decision has to be made, they're able to do it. Now, again, with technology, we do have healthcare agents on the other side of the country. It does work. But as I was kind of doing best practices and writing down what are some attributes, I did write nearby because I think it is easier if it's possible. Somebody who's definitely an advocate, somebody who's willing to upset people, who's willing to ruffle some feathers. The squeaky wheel gets the grease, right? And as much as I hate to say that, it is true. So when you're in a hospital setting or a long-term care setting, your person that you're naming needs to be an advocate, needs to be zealous, needs to be someone who's not afraid to ruffle feathers. They need to be assertive. They need to be a good communicator. And it never hurts to have a background in healthcare, right? We are talking about making healthcare decisions. Yes, a non-healthcare person can certainly get the opinion of the doctors and the nurses. Yes, they can certainly make the final call. No questions asked. But if you have someone who has that background, why not, right? Let them step in there. Let them help make decisions. If they already have the background in it, what the heck? There's certainly going to be someone who is knowledgeable, someone who understands. The decisions will certainly be informed. They're going to be based upon, their background and experiences, which is never a bad thing. Jeff, I don't have anyone in my family who does have a healthcare background. That's okay. I mean, obviously, if you don't have anyone, pick someone who is, an advocate, who's zealous, who's willing to ask questions, who's willing not to be afraid. They can still certainly do it. There's no question. There's no requirement that they have a background in healthcare. Again, as I was writing this, it was more of a best practices kind of thing. Certainly the best practice would be to have a healthcare agent who has a little bit of knowledge in healthcare, if possible. So, if it's there, awesome. If not, obviously pick, among the people that you have in your life. Now, I have noticed, especially in regards to the healthcare agent, that a lot of people don't necessarily sometimes pick their kids, right? So if there's none of their kids who are advocates or who know healthcare or who will stand up for the parents, sometimes people will go with retired nurses, retired social workers, people who, have a background, have done it their whole careers, have an understanding, and obviously, hopefully someone that you're close with. I have seen, a decent bit of that, not quite as much in the financial side, although there certainly are people who are picking local trust companies to act, former trust officers who open up their business. In our York and Lancaster area, there aren't a ton of them, so it's a little harder. It's pretty limited in the people who are doing it. So at least locally, I'm not seeing a ton of that. I imagine in the bigger cities in the state, Philadelphia, Pittsburgh, Scranton, Erie, there's probably a lot more choices. In more rural areas, it's probably not quite as much. And again, around here, there are a couple financial, there are several healthcare that you can choose from. In regards to the fiduciary as the executor in your will, the executor, if he's male, is the person who carries out your wishes if you pass away that you name. If she's female, it's the executrix. So executor is male, executrix is female. That person is also a fiduciary, right? So what are their roles? What are they doing? They're going to be carrying out your wishes. They're going to be stepping in the shoes of the testator and making sure that they marshal the assets, that they get all the bills, liabilities, taxes all paid, that the beneficiaries are kind of being notified and told as to what occurred and what they will be receiving. And then, of course, distributing the assets according to the wishes in the will. Now, the executor does not get authority until they go to the courthouse, or depending on your county, they go on a Zoom call after they have filled out a probate petition. They raise their right hand. They swear and affirm that they will, pay all just debts, expenses, cost of administration of the estate, and make sure that all taxes are paid accordingly. And if they will, they say, I do. They sign, and then, of course, they are granted what are called letters testamentary. That just means that they have authority. That just means that they are stepping in the shoes of the testator. It is now their job to carry out the wishes as set forth in the will. Charlotte, no. So the executor then is the person that's stepping in the shoes of the testator, right? And it is their job then to carry out the wishes in the will, but they only get authority once they are sworn in and once they are granted letters testamentary. They receive what's called a short certificate, which I always call, Willy Wonka's golden ticket. It gives them the authority to do everything they need. But until the moment that they receive it, they do not have authority to step in the shoes of the testator. They have to wait. So from the moment of death until the executor kind of steps in, nobody has authority. But it's okay. It's fine. It's honestly fine. Creditors understand that it may take a few weeks to get paid. People overreact. They make bad decisions, like having kids joint own accounts and doing things that make the assets subject to someone else, subject to the ability to be stolen. And that is absolutely not a good idea if it can be, if it can be stopped or if it can be helped. We have in other podcasts and all of our workshops, we talk about the three lands, the difference between what you're allowed to do in tax land versus what the consequence would be in long-term care land. And if you make a decision in tax land, the implications in estate planning land, in that you no longer control it. So definitely check out the workshops if you're interested in that topic. As a general statement, I don't recommend gifting assets or naming kids as joint owners on accounts. And I think sometimes people do it for convenience, particularly towards the end of life, because they think, I have to get my bills paid. The money will be tied up. As probate is really not bad at all. I mean, it's just a process. It's just the state's rule book. Generally, about a week after the passing, the death certificate's available, usually at the funeral. And then once you get the death certificate, you can fill out the petition. You can schedule your appointment at the courthouse. As we're doing this podcast in November of 2022, there definitely are still a ton of counties, including ours, York and Lancaster, that are doing theirs via Zoom. You'll want to check your local court to see if they're still doing them Zoom or if they're going to go back to live in person. I think a lot of people are liking the Zoom. The attorneys don't have to go downtown. The clients, the executors don't have to go downtown, which is kind of nice. I'll be interested in seeing whether everybody goes back. My understanding is that a lot of counties have already, particularly in York, we have not, and I'm hoping that we don't anytime soon. But I guess we'll wait and see sort of, what plays out and, where people decide. But you'll want to check your local rules to make the determination as to whether you have to go in person or whether you're able to, just schedule that meeting via Zoom. So check out your rules in your area for that one. And I would imagine for at least the next couple of years for some counties. All right. The final one would be the trustee of a trust. I want to make one sort of disclaimer at the beginning here. There are definitely different reasons to do trusts, right? As we've talked about on other podcasts, you might do a trust for tax reasons. You might do a trust for asset protection reasons. After death, you may be providing assets to a child because they're bad with money or because they're in a bad marriage or because you don't trust them. Or it may be that you're choosing to use trust offensively, which is, my son's a great kid, but I don't want him to lose it to a divorce, a nursing home, a car accident. I want him to enjoy the money, use the money, be the only one who can get access to the money, but have some control over it as well. So as we kind of navigate this fiduciary role, the roles itself is the same, but who you pick might change. So for example, if we're doing a special needs trust, it does need to be a third party. It can't be the individual who's being named. And my advice is to try to find a professional. The special needs trust area is definitely an area where it is very easy to make a mistake. And mistakes can be huge because the beneficiary can lose their benefits. So that's an area where, in my opinion, a lot of times it's better to go with a fiduciary that is a professional corporation. We are very lucky in Pennsylvania, particularly we have Achieva Trust, which is out in Pittsburgh. We have Security Trust Company in Lancaster. Both of them do special needs. They do a lot of them. They're very knowledgeable, and they're able to assist clients in guiding them on a day-to-day basis. So in that context, I would recommend a professional. Also, when you're in the context of maybe you're giving money to someone who's horrible with money, and they're a spendthrift or they're an addict or someone that you really can't take a chance on giving them control or giving them access at all. You really have to keep the money tied down. That might be a situation where you look to a professional, whether it be a trust company or maybe at a professional in your area who acts and provides that service professionally, who's insured. Again, if you're trying to keep the money protected and from someone, that's never a bad idea. Beyond that, if there's someone who's responsible, trustworthy, a good advocate, organized, diligent, just someone who is good with money, who is an advocate, who's willing to help and be there for someone. It could be a family member, it could be a friend, it could be a professional. For the other trustee roles, it's not quite as important or necessary that we hire the outside world or we hire a professional. It really depends on the situation. So with an asset protection during life, as long as we're not trying to get the money out of your estate for federal estate tax purposes, which currently is $12.06 million a person. So for a husband and wife, 24.12, I think, if I did the math correct. That's a lot of money. There are not a lot of people who have that kind of money. If we're doing a tax trust because they do want it out of their estate, then yeah, you definitely you have to pick a third party, and you may want to pick a professional if you're dealing in that kind of wealth. But you could hire a family member that you really trust. When we're dealing in the asset protection arena and we're not trying to get the assets outside of the estate, you can be the trustee of your own trust. And that is certainly what most people prefer. It's totally up to the individual, but you are allowed to be. And then beyond that, you're going to want to pick someone behind you, maybe a child who's very good with money, who's responsible. Again, we're kind of keeping it in the family if possible. We're not trying to tie it up. We're not trying to keep it overly protected. And then after death, when we're giving it to the children or grandchildren, that just kind of depends on the person. If you're giving it to someone who's very responsible and who's good with money, you're just trying to keep the money protected for them, not from them, then they can be their own trustee and name a co-trustee. Maybe it be another family member, a sibling, someone else who will act with them in order to be able to meet the requirements for the asset protection piece. So in that context, for example, if I was receiving a trust, I would want my sister Dina to be my co-trustee, right? I trust her. She's good with money. I know she would do the right thing. So in that context, I also know that I'd be able to get access to it if I needed it. Now, the person who creates it can give me the right to fire my sister. Now, obviously, if I'm an addict, if I'm a spendthrift, you're not going to give that person the right to fire the other person. That would just be silly. But in a case where you're not trying to keep it from them, you're trying to protect it for them, you are allowed to do that. But that person is still a fiduciary. That person still has to meet their obligations. They still need to be diligent. They still need to be good with money, organized, and all those things. But I may have more flexibility in a situation where we're dealing in special needs or spendthrifts or bad marriages or just bad decisions. You won't want to give the right to fire in that context. You're going to want to have them stuck with the person that's named in that fiduciary role. Remember, in a fiduciary role, you're held to a higher standard. Now, you really don't have liability per se, as long as you're acting in the best interest and you're not stealing, you're not taking money for your own benefit, you're only using it as intended in the trust. For the most part, there's really no liability there. Now, obviously, if you're stealing, sure. If you're taking money for yourself, absolutely. If you're taking money and giving it out, absolutely. But beyond that, as long as you're acting in the best interest, you're going to be fine. I also recommend that somebody who is not well-versed in managing of assets, just because you're the trustee doesn't mean that you can't seek outside help. So I always recommend that they seek the advice of an investment professional, have that person help them with the investing part if there are assets to invest. It's kind of the prudent person rule, the reasonable standard, right? Where as long as you're acting reasonably and you're not doing anything malicious or intentional to hurt someone, you're going to be fine. There won't be any liability there. But I definitely, if there's a lot of money in the investment side, seek outside counsel, seek advice of an investment professional, a financial advisor, CFP. They'll be able to guide you on the investment side. You focus on the part that you need to focus on, which is, paying the bills and being organized and keeping track of the money. Let them handle the investment part that they're good at. So, I hope you enjoyed the podcast today. We got the opportunity to talk today about fiduciary roles, who are held to a higher standard. A fiduciary is someone who is granted power or property entrusted for the benefit of another, and they are held to a higher standard because they owe the person that they're acting a higher duty, right? A duty of loyalty, a duty of care, and they have to act in the best interest of that individual. If you enjoyed this topic and you'd like to see the fiduciary workshop that we're creating, please check us out at www.bellomoassociates.com or at 717-845-5390. And we would be more than happy to get you into that fiduciary workshop or any one of our other workshops. Remember, this show today was intended for informational and educational purposes only. It did not stand for or constitute legal advice and did not create an attorney-client relationship. If you have a specific issue, please contact an attorney in your state. If you're in Pennsylvania and you're looking for anything regarding to estate planning and elder law, please check us out, www.bellomoassociates.com. We'd be more than happy to help you. We hope you enjoyed this episode of the Red Wagon Estate Planning and Elder Law Show. Please be sure to check our workshops out so that we can help you and educate you so that what happened to my family doesn't happen to yours. We look forward to seeing you on the next podcast. Have a wonderful day.